Ladies and gentlemen, that's our third academic scientific panel. I'm quite convinced that it will attract your attention as a closing scientific panel today, closing the first day of our conference. Let me firstly shortly greet and welcome my distinguished colleagues, starting with Emilia Mišćenić, Monika Namysłowska, Klaus Wippemann, and Adrianna Michałowicz, and also remotely Julia Kalpokienes joined us from Lithuania. Welcome, guys. Thank you very much for coming. I'm really proud of your attendance. I was thinking about how should I start, but before I start with any specific consumer-related content, let me also welcome another important group of distinguished guests. Many times today, national agencies has been referred to, and I'm very proud to welcome today in Poznań the heads of Department of Protection of Collective Consumer Interest from the Polish Office of Protection of Competition and Consumer, represented by Mr. Łukasz Broński, Director, Mrs. Katarzyna Araczewska, Deputy Director, Ms. Sylwia Żurek, Deputy Director, and also we have here from Katowice, Deputy Director of the Silesian Branch Office of our Consumer and Competition Agency, Agnieszka Doring-Szyrszeń. Welcome, and let me stress that we are thankful to the President of the Office for Protection of Competition and Consumers, Mr. Tomasz Chrusny, who has kindly granted us the patronage for the event today. Thank you very much for that support and also attending the conference. I hope your input and for your input also maybe within the discussion. But I saw you gathering together with Mrs. Risenbeck from Commission. So behind the scene, something is going on. I like it very much. That's the important point of having these kind of academic meetings. Guys, I wanted to refer to one first quote from 1776. That is saying, let me shorten it a little bit, because I'd like to my speakers to have time for their presentations. So 1776, somebody said that in the mercantile system, the interest of the consumer is almost constantly sacrificed to that of the producer, and it seems to consider production and not consumption as the ultimate end and object of all industry commerce. Okay, now let us move 200 years ahead. 1975, when you make a search in electronic data of European Economic Community, you will find a document that has been adopted by the EEC Council from April 1975 that says the consumer is no longer seen merely as a purchaser and user of goods and services for personal, family, or group purposes, but also as a person concerned with the various facets of society, which may affect him either directly or indirectly as a consumer. Of course, the first quote comes from Adam Smith, who was an eyewitness of Industrial Revolution. The second phrase comes from the first policy program of European Economic Community on consumer protection. And it seems we needed 200 years to change the approach, more or less, of course. Now we are 50 years later, that's 2025, after Council has adopted its first preliminary resolution on the consumer protection program. What has changed in between? Is the fact that we are challenged, and we are challenging the Industrial Revolution 4.0 or informational revolution. Does it require to change the way how we perceive things, and especially consumers? I hope many of these questions will be presented by my distinguished speakers. I'd like to start with Emilia Mišćenić, and let me help you with the presentation.
I hope you can hear me well. Yeah, it's fine. Okay, thank you. So first of all, I want to really thank you. I really want to thank to Professor Nestor, to Igor for this lovely introduction and for the invitation, and also to all the organizers of this wonderful conference. I'm so glad that I'm here in Poznan and that I'm able to participate in this interdisciplinary event. So I'm also grateful for the opportunity to be able to discuss with you the question that you can actually see on the first slide. So is the EU consumer law fit for purpose? And is it actually fit for the challenges of the digital single market? And in that line and in the line of the overall conference theme, thank you. I want to remind us all actually of the roots of the development of the EU law, consumer law, and consumer protection. And without going into details of this historical background that you can see on the slide, it's important for us to remind that actually consumer protection at the EU level developed as an adjunct to internal market policy and single market policy. And over the years, it became one of the most important union policies. And also, I would say, a key instrument for the establishment and the functioning of the internal market. So, as we all know, or we are supposed to know, yes, that the so-called positive integration and positive harmonization, including, of course, the adoption of EU consumer directives, started and developed on the legal ground and on the competencies of the internal market. And this remains so until today. And today's article 169 of the Treaty on Consumer Protection is actually simply referring to the adoption of approximation measures, meaning also EU consumer directives, on the legal ground for the incompetencies of the internal market. While the horizontal clause demanding the consumer protection in defining and implementing the other union policies and activities, which was introduced with Amsterdam Treaty, with Lisbon moved to general provisions to the front of the treaty, Article 12. And the constitutional dimension was also recognized by the Charter in Article 38. When it comes to the Court of Justice case law, again, as we all know, although the Court of Justice was one of the initiator in the protection of consumer rights, we all recall famous cases such as Cassis de Dijon. It was also very fast in setting the limits when it comes to the harmonization on the legal ground of the internal market. So here you can see the first one in tobacco line cases, and where it was requested that these approximation measures adopted on the legal ground of the internal market, today is Article 114, they need to genuinely, this means also, of course, EU consumer directives, they need to genuinely have as their goal and follow the establishment and the functioning of the internal market. Competition distraction, they have to be distortions, or they have to be appreciable. Also, the measure which is proposed, it has to actually eliminate obstacles to fundamental freedom. And in this line, I ask ourselves, or we should ask ourselves, if the consumer measures of today are really satisfying all these conditions. And if we look at the slide, whether the consumer measures of today are really designed to prevent future obstacles to trade, but not only resulting from the multifarious development of national laws, but also from this speedy technological development that we have heard so much about today. So the answer to some of these questions can be found in the recent digital fairness fitness check, which was basically questioning the adequacy of these three main consumer directives: Unfair Commercial Practices Directive, Consumer Rights Directive, and UCTD, Unfair Contract Terms Directive, to the requirements of the digital environment on the basis of these five criteria. And without going into detailed analysis of each of these criteria, the conclusion was that the current EU consumer law is overall efficient when it comes to digital environment. However, when we look at the at least first 3 points, when it comes to the effectiveness, effectiveness is limited because of the huge problem with the regulatory fragmentation. Then when we look at the second point, the coherence, you can still see that the coherence between the 3 directives is strong, but it's actually quite weak when it comes to the coherence with the digital acquis that we were listening the whole day today. When it comes to the efficiency, overall efficient, but again with limitations due to large discrepancy between the costs, meaning costs which are caused online, consumer detriments and harms. There is a huge discrepancy with the compliance cost, business compliance cost, as you can see, and these harms to consumers in digital environment are estimated yearly almost they are not 8, but almost 8 billion per year. And of course, the statistics, they confirm this development. We heard today about the e-commerce. And of course, the online shopping is always and constantly on the rise. According to these recent Eurostat statistics, 94% of people visited the internet, but 77% bought some kind of goods or services. And while this online shopping is on the rise, the violations of the consumer acquis that we heard is overall efficient is also on the rise. So here you can see different results for over the past few years, some older, some more recent, from 2019 older, but these are from March, actually, 2025. European sweep actions are actually confirming that more than half of the traders acting online are violating different kind of information duties, transparency requirements, usually the pre-contractual information duties, by not informing consumers of their essential rights and obligations, rights such as right of withdrawal, right to remedy on the legal guarantee. And of course, they use plenty of unfair commercial practices, especially digital ones, such as dark patterns, manipulative design, tracking, profiling, that we will hear more about by colleague Monika Namikowska. So I will not go into details. But when it comes to this average consumer that we also heard today about, who is defined by the Court of Justice case laws and reasonably observant, attentive, and circumspect, he or she actually becomes weak, we will say, and vulnerable in digital environment. And I would say not only because of the personal characteristics that you can see here under the new consumer agenda, or of course, or the problematic setup of digital environment as from the BEUC study, but also because this average consumer, he or she simply doesn't know, doesn't understand the complex language behind every online shopping. They are not even aware of complexity of algorithms, of programs, of ledger technologies, all running behind one regular online shopping that we are doing from our sofas. Yes. So, and which actually lead consumers to choices which are not informed choices anymore, or not their own choices. So if we imagine this average consumer who is, according to our view, weak and vulnerable in digital environment, having some issues and problems with a trader, online platform, any kind of online businesses, and who tries to solve this issue, a consumer is simultaneously faced with more than 10 different legal acts arising not only under the consumer acquis, but also the digital acquis that we heard of today. I will not name them now individually. You can see them on the slide. And of course, this consumer has serious difficulties in finding his rights and also essential informations. And even once, let's imagine that even once this consumer really detect the applicable legal act to this particular situation that he is in, then he's faced with this. Yeah. And this is, I would say, a normative obstacle of reading and understanding EU consumer directive, which are transposed into our national laws of the member states. Here you can see three examples. These are three different examples: pre-contractual informing under the Consumer Rights Directive, under the Consumer Credit Directive, under distance sale of financial services that amended Consumer Rights Directive. So these are all the informations that the traders are obliged to provide to consumers in a clear and comprehensive manner, meaning in a transparent manner. So it's very unlikely that an average consumer will be able to recognize his rights and obligation and essential information from all these information that we can see on the slide. And of course, digital fairness fitness check is recognizing the risk of information overload is not a novelty, yeah? But in terms of the digital environment, it becomes worse and worse. And also it recognizes that consumers' online behavior changes, that they are less likely to pay attention and be able to process all the informations in digital environments. But when it comes to different proposals of simplification of these information duties, which are the tool for achieving the transparency, the fitness check is considering that simplification of these rules would create unnecessary compliance costs to traders, although the traders are actually not reporting such a compliance cost. The digital fairness fitness check is also recognizing that directives lack necessary concreteness for the effective practical application, that there is a need to ensure consistent application of EU consumer law and other legislation. And I would say maybe the best or most beneficial comments comes from the study, the supportive study to the digital fairness fitness check, emphasizing the fact that EU consumer law needs to be actually updated to address the challenges of the digital single market that we have heard so much about this morning. Of course, this is all confirmed by the case law. I will not go into details. Here are just some of the cases arising with issues which are connected and relevant for the digital environment. But for instance, we can see in Tiketa that the Court of Justice adjusted to some of the challenges of the digital market in form of saying, as you can maybe see on the slide, that it's acceptable to provide pre-contractual information by ticking the box on terms and conditions, but only under the condition that these terms are really transparent, as you can see, in a clear and comprehensible manner brought to consumers' attention, and only under the condition that all these contractual terms, once the contract is concluded, were, of course, given to the consumer, provided to consumer on a durable medium, because they form part of the contract. And why is that important? Of course, it's important because this average or vulnerable consumer, if he or she was not informed in a transparent manner, they could not be aware of the economic consequences and, for instance, of ticking this box of terms and conditions on traders' website. And the consequences, we have seen the consequences, for instance, in Poland or in Croatia, where I come from, in the Swiss franc scenario, where this actually led to the unfairness of the contractual term, and it could also eventually lead to the unfairness of the whole contract. So I will, instead of the conclusion, I will actually just enlist here, and I enlisted here different kinds of proposals coming from the practitioners and legal scholars, a possible solution to address some of these challenges that we were discussing today, and that I have also mentioned. But it actually remains to be seen, and I hope to hear more from the next speaker, in which way and how the announced Digital Fairness Act will approach this issue. So without going into further details, I will end up my presentation as in the movie, to be continued. Thank you very much for your attention.